Good morning. Hi, everyone. Welcome, welcome. We are going to wait about one more minute and let all of our participants get logged on, and then we're going to get started real soon here. All right, we're going to go ahead and get started. Thank you so much for joining our webinar on everything you need to know about professional fiduciaries. I'm Stacey Grow. I'm the Director of Marketing and Client Experience at the law offices of Daniel A. Hunt. And we're really excited to be hosting this webinar this morning. If you've missed any of our previous webinars, they're available, recordings are available on our YouTube channel. We're also recording this session today so that it can be made available on our YouTube channel as well. To find our channel, you can go to YouTube and just search Law Offices of Daniel Hunt. We have currently nearly 70 educational videos uploaded there. So if you're interested in checking that out, it is available for free. Tomorrow, I'm going to send a copy of a PDF of our slides from today's presentation and a link to access that recording by email. So look for that. A few housekeeping items as we begin. Go ahead and go to the next slide. So if you're new to Zoom, if you move your mouse down to the bottom of the screen, you're going to see your controls. On the bottom left is your audio. You'll see a chat box where you can communicate with the hosts. You also see a Q&A box, and that's going to be where you can type any questions you might have as we proceed. We will be having a Q&A session at the end, so you can type in your questions at any point during the presentation. Feel free to do that. We anticipate that our webinar today is going to last around an hour, including the Q&A session. So if you do have a question that is specific to your circumstances, we're also going to be sharing contact information for our speakers at the end so that you can reach out for personalized advice. So with that, I'm going to go ahead and introduce our two speakers today. We have Daniel A. Hunt. He is the owner of the law offices of Daniel A. Hunt, a certified specialist in estate planning, trust, and probate law, and over 10 years of experience working with professional fiduciaries in trust and estate matters, particularly. Our other speaker who we're very excited to have today with us is Susan Didriksen. She is the owner of Northern California Fiduciary Services. She's licensed insurance and insured and bonded California Professional Fiduciary, accredited investment fiduciary with over 25 years of financial and accounting experience. And we worked with Susan many times over the years. She's always been great to work with. And so we're really excited to have her here today to share her knowledge with us. So at this point, I'm going to go ahead and turn over the time to our speakers.
Good morning. So we'll start with what a professional fiduciary is. And really, if you think about a professional fiduciary and when you're choosing one, if your needs are requiring that, you're looking for someone who will fill in your shoes for either when you become incapacitated or pass on. So a fiduciary is someone who you hire early on, and when the time is right, either incapacity or through death of a grantor of a trust, that person is paid to act in a position of trust on behalf of you as the grantor of your trust. Typically, fiduciaries serve as trustees, successor trustees. So if you have a trust, right now you're the trustee and the grantor of the trust. But if you become incapacitated, a successor trustee could come along and then help pay your bills, help arrange for care, help arrange for any additional activities or assistance that you may need in your life. And a fiduciary can also act as an executor of an estate. Typically, that's appointed by a court in probate when someone dies without a trust. The other two areas where a fiduciary can work as an appointee by the court is a conservator of either a person or a conservator of estate. And sometimes the conservator is both of person and of estate, but estate would be dealing with the monetary aspects of the person who is conserved. Conservator of person would be dealing with the social, medical, other types of personal needs of the conserved person. Fiduciaries also act under a medical or durable power of attorney. So a financial power of attorney, say you envision or may have a relative who is going through some maybe difficult times with cognitive abilities and maybe needs some assistance in paying bills, reconciling a cash or checking account, reconciling bank accounts, reviewing investments with investment advisors. Fiduciary could fill that role as well, and then facilitating everyday financial tasks like paying bills or paying caregivers.
Morning, Susan. Hey, question. You said at death
Yes.
and incapacity. So what about if somebody, they just don't want to do those kinds of things anymore? Can a fiduciary do that as well?
Yes, that's also true. Sometimes I have clients who say, well, I still have my ability to have cognitive awareness, but I don't really care to pay my bills anymore. I want someone to help with that. I kind of need a personal assistant in a way, but I want someone who has more responsibility and more maybe accountability because I'm going to give them access to my checking account, access to paying my bills, access to meeting with financial advisors. And a fiduciary can fill that role. Usually that role would be filled under a financial power of attorney. And in my case, if I have clients that request that, I meet with them once a month to gather their bills and then provide an accounting of their bank statements, what bills were paid, and then also arrange with meetings with them and their financial advisors and also their tax CPAs to complete their taxes.
I'm considering long and hard doing that myself, just because I hate doing the bill paying. Another question. When do you have to listen to your client, and when do you not have to listen to your client? Because I would think that, for example, if I say, hey, I'm just tired of paying my bills and I want somebody else to kind of manage bill paying and even my investments for me, and I'm going to turn that over to Susan, a professional fiduciary. And then I say, Susan, I want you to invest $100,000 in Bitcoin for me. Do you have to do that? As opposed to, I'm a beneficiary of a trust, you're managing my assets for me, and I say, Susan, I want you to invest $100,000 in Bitcoin for me. Do you have to follow that instruction? Can you talk about that for a second?
Right. So if I'm hired as a fiduciary, then I also have to follow the Uniform Prudent Investor Act, which is an act that guides and puts requirements on fiduciaries as to what they're able to invest in. Typically, it has to be a diversified portfolio that is with stocks and bonds, and then according to the time frame that the beneficiaries are expected to live. So for example, if it's a special needs trust for younger people, then it would have more stocks than fixed income assets. If it's an older person, then it's going to tailor down some of those stock investments, some of that those riskier assets. But if I'm operating to help someone and they say to me that they want me to make that investment, then I would say, well, I respect your decision to make your own investments, but that's something that you would have to do on your own. I could not do that for you. That would just be against the rules of the Investor Prudent, or the Prudent Investor Act, and that would be a liability for me. But I do have, in certain situations, trusts that are very specific as to what I am to invest in, or the assets that are to be held as in the trust. So, for example, a trust that has a lot of real estate investments and maybe no stocks or bonds, that would be considered a relatively risky trust or investment because it's not diversified. So under the Uniform Prudent Investor Act, I would not independently put all of the money into real estate. That just wouldn't be something that I could do under that act. But if the trust is already invested in that, and the trust is specific as to what those assets should be, and what the trustee's role is in managing those assets, then yes, then I would maintain those assets.
Okay, great.
So the qualifications that a professional fiduciary has, number one, we are licensed in the state of California. So for any fiduciary that is managing 3 or more cases for non-family members, you have to be licensed. And there's 2 ways in which you can have a fiduciary. Doesn't have to be licensed, but they have to actually be licensed in other professions. And those are CPAs and attorneys. But part of the licensing process is that there's initial courses that have to be taken. There's an exam. There's background checks. We have to have the ability to be bonded. And also we have continuing education classes that are required. What responsibilities does the fiduciary have? Well, first we have to abide by the California Probate Code. And there's certain aspects of that that define the care and the care for both the client and the care for the client's assets, and the duties that a fiduciary has. We have a code of ethics. For example, we have to avoid conflicts of interest. So I, in my role, will arrange for care for a client to have assistance in the activities of daily life. But I could not own a care company that I then contracted with to provide that service. I have to interview and work with several care companies to get the best type of service, the best rates, and then they will send people to interview with the client, and the client ultimately decides who they feel is, if they're able to decide who they feel is the best fit for them. We are then also responsible for the actions that we have when we hire people, professionals. So we'll hire realtors. We may work with existing investment management companies or hire an investment manager. And we're responsible for making those decisions. Now, of course, if the investment manager is doing something completely with malfeasance and is hiding assets or hiding results, and that's not readily detected, and there's several people or all of their clients are being duped, that wouldn't mean that the fiduciary is responsible for that. But as long as the fiduciary has provided the right analysis, has conducted the right analysis of the stocks and the mutual funds that the company is invested in, and has met with the investment advisor and received reports. So if the investment advisor is just producing reports that are false, then that's a criminal act, obviously, on the part of the investment advisor. In my cases, though, all of the investment advisors that I use have third-party custodians. So you never are relying on the investment manager to provide those reports. That reporting is done by a third party, such as Fidelity, Charles Schwab, Ameritrade. The investments are readily identified, they're readily checked and verified.
Another
yes.
question, Susan. If you were done with that thought, do the professional fiduciaries get treated differently in the probate code than a non-professional fiduciary?
Yes. I mean, there's a different level of expectations. There's that doesn't mean, though, that a non-professional fiduciary won't be removed if they're not performing the duties of a trust or performing activities that are to the benefit of their beneficiaries and the people that they serve. But the expectation is that a professional fiduciary is going to be held to the strictest standard. I've been involved in being an expert witness in trial cases before, where in many cases it's a non-professional fiduciary. And while the judge is lenient with the expectations of that person, in the end, usually that person, if they've had some negligence, they will be removed as a trustee.
So a higher kind of standard, saying like, hey, if this is a non-professional and they, were late on an accounting or something like that, maybe they're going to have some leeway with that non-professional, saying, hey, you need to get us that accounting ASAP. Whereas a professional fiduciary is going to say, you should know better, you're not doing your job, and they'll be quicker to remove them. Is that what you're saying?
I think that I think in both instances, in that case, the court will just ask for the accounting, and if the accounting is produced in a timely manner, they'll be accepting of that. But if the accounting has problems, actually in both cases, if the accounting has problems, the non-professional is going to be held to the same standards in the accounting. And that gets to this last point here, that fiduciaries are accountable to the court for losses that they incur through improper asset management or through negligence. So it doesn't matter if you're a professional or a non-professional. If you take on this role, you do have to have the knowledge that you are in charge of these assets, and if anything you do that's improper, you can be held liable for it. So, for example, I know of a case where the trustee did not have proper insurance on a structure. It was a home that was that the grantor of the trust had in the trust, but the grantor died, and the trustee maintained the existing insurance. They had insurance, but they never told the insurance company that the home was vacant. And anyone who's had a vacant building for more than the current time period of turnover, maybe, or re-renting it or selling it, knows that there's a separate policy for vacant building, and not all insurers will cover a vacant building. And also the separate policy is a lot more expensive. So that resulted in that fiduciary, when they, even though they weren't a professional, when there were losses on that, they became liable to those losses because the insurance company would not cover those losses.
And how often do you account to your clients?
So mine can be based on the court accounting and a conservatorship, which would be once a year. But if I have ongoing trusts, There's some clients that I count every month. There's other clients that want to see it quarterly. So I'm very flexible, and I'll work with my clients on beneficiaries on how often they want to see the reporting. Once a month is probably unless it's a really large trust with a lot of maybe a business, like there's some that have real estate and have rentals coming in. So once a month you have to do that anyway. So for me, it's very simple then to just email it to my clients or send it in the mail.
Great. Okay, so I think it's my turn now to talk a little bit. So 3 signs that a professional fiduciary may be right for you. First one, you're struggling to find a suitable family member or friend. This is obviously the number one sign that you have professional fiduciary is probably going to be right in your case. You're sitting there and thinking, well, I can't really decide on which family member is going to be the best fit or friend. Then you're obviously going to be turning to someone that's a professional fiduciary. But I also caution, you can just throw them all up right now, Stacy. I'm going to kind of talk about all of them. Thanks. So when you have someone that for example, this happens a lot where clients of mine, they think they've got someone really, really good that will fit well with the things that a trustee or a fiduciary has to do. They're really good at being organized. They're really a fair person. And it's, this is your son or your daughter, or maybe a sibling or something like that. But there's a beneficiary of that trust or that will that hates that person's guts. They may be the best fiduciary in the world, but it's still not going to be a good fit if they're really not going to be getting along. That's something where you may want to consider and say, hey, let's go ahead and find somebody else. Susan had mentioned, CPAs and lawyers, that they're kind of excluded from having to have like this professional license to act as fiduciaries on multiple states. And many times our clients will be like, hey, it's great. I have a CPA son or daughter, and so I'm going to select them to manage my estate. Well, I've seen it in a couple of cases where that CPA son or daughter, and the one I'm particularly thinking of, they were CPA, but they were a terrible fit as a fiduciary. They were rather disorganized. They also had some substance abuse problems, which made it very difficult for them to do their job. And so the beneficiaries couldn't get answers from the trustee, and ended up being a very long, drawn out court battle, costing upwards of hundreds of thousands of dollars, upward of $100,000 to get this fiduciary to do their job. When you are being told by the court that you have to account, and you actually have to appear to the court and tell them why you didn't file your accounting that was ordered previously, and yet you are totally drunk that morning that you've got to go and account to the court, it's a bad sign. Even though that was a CPA we were dealing with, you want to be careful. And lawyers as well. I'll say this, picking, because it happens all the time where they'll say, oh, I'm going to pick my son, daughter, sibling, whatever, that they're an attorney. And so they'll be really great at this. I've had it where I've had to go to court and do battle over the removal of the attorney son or daughter that was the fiduciary, because many times attorneys, we think we're very, very smart. And we also think that we're always right. And in this case, unless that son or daughter is an attorney that specializes in trust and estates, the rules, as I say, oh, here we go. I always like to show this. Where is my, oh, it's right here, hidden. The probate code right here. That's thick. You got to know all that stuff. So unless you're an attorney that specializes in that, you're not going to know the code that governs you. So picking an attorney who is like, okay, they're going to do this, but they don't know the code, that's going to be problematic. And so I've had to butt heads with fiduciaries who happen to be an attorney, but they don't know what they're doing. So anyway, challenging family dynamics, it looks like this, where you don't pick a fiduciary that doesn't get along with one of the beneficiaries. It's just not going to be worth it. If your children, if they really don't get along, it's not a good idea to put one of them in charge of the administration of the estate if they know that one of these kids is just going to fight it the whole way. Because even though they're doing a really good job, and this has happened so many times, it's very, very frustrating that we represent these fiduciaries who they're good at their job. They really are. But you got one kid that just hated their sibling and can't stand that the oldest, who's always been in charge of everything, is now in charge once again. And they want to question every single thing that they do. And that fiduciary has to answer those questions, even though it's costing the trust money and it's costing all the beneficiaries money. Because Susan, I think we'll maybe talk about this in a bit as to how these things get paid for. But if you have one beneficiary that just wants to be the thorn in the side of their sibling that they have had it out for over decades, that trustee still has to answer their questions, and the trust funds get used to pay for it. So that's where we end up. We just wrapped up a case that had been going for probably pushing on 3 years. And quite frankly, the fiduciary was doing the best that they could in a very complex situation. But these family members had this kind of personal vendetta against them and spent many, many thousands of dollars in dragging her into court so that they can nitpick every single thing that she did. So when you got those family dynamics where people don't get along, you're best to just pick someone else where they can all get along. And then third thing there that's mentioned, you're looking for a trustee for a long-term trust, for example, special needs trust. Having a family member act as a fiduciary for decades can be kind of exhausting to them. And also having them manage another family's money for that long, where it's just, it can turn into just an adversarial relationship where the beneficiary is constantly asking for more and more money from their family member trustee or fiduciary. And that fiduciary is sitting there saying, I'm trying to do my job. I'm trying to follow what this says, and what you're asking me to do isn't what this says. And so they're torn between giving in and listening to the beneficiary, but not following what the terms of the trust are, or that will, that whatever it's set up as. They're not going to follow that. And so they're going to breach their fiduciary duties and go ahead and do whatever the beneficiary wants them, and then get in trouble that way. So many times it's best, where if it's going to be this long-term trust, like a special needs trust, it's going to go for a lifetime. It's best, in many cases, to have a professional handle that, so that the siblings or the aunt-uncle relationship to their niece-nephew can remain that relationship, as opposed to being pushed into a more professional relationship where you're sitting there holding someone else's money. I always tell them, just consider that, because once you turn into the I'm now holding your money, the relationship of aunt and uncle or sibling can sometimes get destroyed, because they know that's the person that's holding my money. They're not listening to me. They're not giving me enough, and you don't want to do that. So it's something to consider. Any thoughts that you have on any of those, Susan?
No, I agree with that. A lot of cases, what I have experienced is that I come into it after maybe a family member has been a trustee and has realized that it's not something that they want to continue doing, that maybe some of the beneficiaries are fighting with them, or arguing with them, and they just want to kind of extricate themselves from that, because they see the family relationships being ruined by continuing that involvement.
Yeah, that happens where, and we may, in setting up the plan, say, okay, we can try with a family member first, but if that doesn't work, then naming a professional fiduciary as an alternate, so that when the family member gets in there, they're like, hey, this is not what I signed up for. I didn't sign up for Family Feud every day of my life, they can resign, walk away, and then professional fiduciary steps in and says, all right, everybody looks like you're going to get along. Now I'm here to handle this thing. So good point. All right. Now, on this one, choosing the right professional fiduciary for you, I think I'm taking 1 and 3 here, and Susan doing 2 and 4. So first, asking for referrals from other professionals. So that is really a great way to go about it, because we are the ones that have worked with the professional fiduciaries before. So we know what they're good at, what they're not good at. And we know the good ones from the bad ones, because it's like, yeah, I'm the one who's been in court with the bad ones going after them. Then I'm also the one that unfortunately has been in court with the good ones defending their actions. So asking your attorney, asking maybe your CPA, your financial advisor, any of these professionals that have worked with them is a good idea, and digging a little deeper so that it's not just literally, oh yes, I've heard of this person, and you can go and talk to them, but honestly being like, yeah, I've worked with this person for years. We've been through a lot. We've been through a ton of trust administrations together. We've even been to court together on things. We've won, we've lost, whatever it may be. Getting the honest opinion from that professional as to who's going to be the best fiduciary. So that's first.
You can also run background checks. First would be to look up the license, name or number, and you can check that and on the California Secretary of State website under the Department of Consumer Affairs, the Fiduciary Bureau. You just type in their last name or their license number if you know that. I would always try to go beyond Yelp or Google reviews. Sometimes I don't have any of these for my business, but I've had people contact me and they said, well, I read the reviews under another fiduciary and it made me worried. And I said, well, it could have been a beneficiary that was upset that they didn't get more money or something. So you have to go beyond really those initial reviews that are on the internet. So I would try to not read those as much. And I always tell people that. I said, go back and ask your attorney, ask your financial advisor, your CPA, if they've worked with this person before you kind of write them off. So I think that getting number one is really helpful, getting those referrals from other professionals. And then you can ask a fiduciary for professional references, either attorneys or CPAs or financial advisors that they work with. That's usually a good indication of how they work and how their performance is.
And then also I might add, not just asking them for the professional references, but also just like your clients. Like if somebody wanted to, if they're okay with that, because I know that Susan, you can't go out and spread who you're working for or anything like that. But if you had some where you're like, oh, it's okay to can I use you if somebody wants to know, like, do I respond well? Am I available? All that kind of stuff. They want to see what it's like being a client of yours. And if you had clients that they could talk to, then obviously you can ask that. But some, of course, they can't divulge, of course, who their clients are and who they're doing work for. So a thought there on number 3. Number 4, interviewing potential professional fiduciaries before making your final choice. Honestly, it could be where if it's a matter of that you're going to be incapacitated or I don't know, even impaired just a little bit, but you want to make sure that it's a good fit for you. And also thinking, okay, well, will this be someone that my beneficiaries, many times your children, that will be a good fit with them? Checking on their education, work experience. It's obviously somebody who's been doing it for just a year. They're going to be somebody that you might be running more of a risk on because they don't have that much experience, as opposed to somebody like Susan has been doing it for a really, really long time. So interview them, make sure it's a good fit. It's always like I tell I tell my clients that come and say, hey, we don't have a good family member, or we have a good family member, but it's bad. They're going to butt heads with somebody. So we just want to pick somebody that's a neutral fiduciary. And I tell them, here's some names, go talk with them and see if that's something that will fit in your case. So talking to people, it's a great thing.
So the costs of a fiduciary are usually determined by a rate that's put out, an hourly rate that's put out in advance, similar to like an attorney. And it can vary according to needs that people have, but typically in trusts, I charge an hourly rate. And some fiduciaries may charge a monthly or an annual rate or a percentage basis. But from my experience, I've just found that it's easier if I charge an hourly rate, keep those time charges in Excel, and I put in the time that I started, the time that I ended, and then I prorate the minutes or hours according to that hourly rate, and then I put what I did. And all of that is reviewed before I get paid by either beneficiaries or by the court. And so I never pay myself really until if it's a trust that gets distributed, I pay myself at the end of the distribution period after the taxes are paid out of the amount that's reserved, and everyone can see what my time charges are. But I would always ask your fiduciary what their fee structure is. So you know what to expect. You know if it's going to be a percentage of the assets that they're managing, or if you know that they're going to charge an hourly rate, or maybe it'll be monthly or annual. If a fiduciary is appointed by the court in a probate matter, however, there usually is a different compensation structure, and that's going to be based off of percentages and of the assets that are administered. So that will be different than if you're hiring someone to be the trustee of your trust. And also there shouldn't be any fees that are charged until services are rendered. I don't know of any fiduciaries that have retainers or charge just to meet with you to be interviewed, or and I never do that either.
Yeah, big one is that the fees must be reasonable. So, and then it says, okay, well, what's reasonable? That's obviously open to interpretation, because you're going to look at the results that were achieved by the acts of the professional fiduciary. You're going to look at the size of the estate, the risk, obviously, that the fiduciary took on by running it. You're going to look at the work that they put in. Was it appropriate? All that good stuff. So the fees always have to be reasonable. And so something that comes up, because we deal with this quite frequently in representing beneficiaries, is, and some fiduciaries can be, and professional and non-professional, can be aggressive in their billing. And a fiduciary, for example, Susan, if a beneficiary comes to you and says, hey, I got a real problem with your fees, what do you do at that point?
Well, actually, I've never had that happen, but
good job, way to go, Susan. That's a good sign.
Right, I've never had anyone question my fees. But if they did, then we would go over every line item, and you know, I keep track of that, and I would just, you know, even for my own edification, what was it that they were concerned about, in what areas. But my fees and my time is kept, you know, down to the minute, and everything I work on is put in the comments section, so they can see that.
Yeah, and my point in asking maybe is not every fiduciary is like that. We have we're going to mediation next month, where we represent a beneficiary who took issue with the professional fiduciary's fees. They charged like $50,000-$60,000 on a very modest estate, and the beneficiary was looking at kind of the injuries for what was going on, and you know, he was charging for these 20-minute phone calls in which they were like talking about just like the weather, totally non-related stuff. And the beneficiary was like, I can't believe that you called me up, asked me a simple question, and then kept me on the phone talking about, I think it was honestly like Led Zeppelin concerts. Then you charged me for that. And when they brought that up, the fiduciary was like, well, that was my time, tough luck, wouldn't change it. So that's when she, of course, came to us, and we had to take that to court because they would not budge on their fees. And now it's getting even more expensive because of that fiduciary just saying, nope, I'm not even gonna, like, my fee is my fee, that's it, I don't care if you have problems, as opposed to having a conversation about it and what could possibly resolve it so that everybody can move on. So anyway, that's my point there, is that not all fiduciaries
Right. If I were to do something like that and someone called me on that, I think, I mean, like, one, I wouldn't do that. But if I did that, there would be no way I would try to defend that. Sorry, I just couldn't defend that.
Yeah. Okay. I think we're now to the biggest mistakes. All right. So first, biggest professional fiduciary mistakes to avoid. First, not asking for references, other trusted professionals, past or current clients. So that, I hope that anybody listening to this webinar now in the future never just appoints or selects a fiduciary without getting references. Because I honestly, when I'm dealing with it in my professional area where I have to either defend or sue professional fiduciaries, I obviously know there are some that I would recommend because I've worked with them. I've not only worked with them, maybe in court, I've seen what they've done, and they're great. And then there are others that I would not touch with a 10-foot pole, like the one I was talking about previously, who charged thousands and thousands of dollars and really accomplished kind of very little for what they had charged. I would never recommend that person. I would hope that they'd be out of business soon. So number one, not asking for references. Don't do that. Don't do that. Always ask for references when it comes to professional fiduciary. Susan's going to talk about this next one.
Sure. The second one, choosing a fiduciary with too heavy or too light of a caseload. Obviously, too light may signify either that they're new to the profession, or that maybe they have had some clients that have left, because most of the fiduciaries I know have really good caseloads. Too heavy of a caseload, that could just mean that, you know, your case may not get the personalized attention that it needs, and there may be delays. If you have to choose, though, obviously I think it would be better to go with someone who's too heavy of a caseload, because eventually they'll work through everything, than too light of a caseload, if you have to choose that.
Agreed. I think of also like selecting attorneys. You wouldn't want to go pick an attorney that's sitting there waiting for the next case to walk through the door and he doesn't have anything to do in the meantime. I always love it when people apologize if they were late for their appointment, and there's, oh, I'm so sorry, I'm, you know, whatever, 10-15 minutes late for my appointment. I'm like, it's okay, I've got other things that I can be working on. But also the too heavy the caseload, that once again, where it's like, okay, are they going to be able to get to my case? But like, you have err to the side of too heavy, because they'll get the good ones there. There's a reason why they have a lot, but also you don't want to get to somewhere it's you're not even going to be heard. So really, once again, relying on those professional references, and then making sure that they've got time for you and that you're not their only client, because that would be a big concern. Okay, number 3, choosing a fiduciary who struggles to communicate in a timely manner. I can't count how many beneficiaries I've represented where, and Susan's going to talk about this as well, where there's some that, you know, they're calling 7 days a week, every hour on the hour, and that's a little much. I'm talking about, I've represented beneficiaries that they say, I can't get my fiduciary to respond to me. I've called and it's been a month and I haven't heard from them. That's problematic. If it's a matter of, you're not the person who's calling every day on the hour, but you're calling, you need something, and it's been several days and you haven't heard from your trustee, your fiduciary, that's problematic. You need somebody who's going to be able to communicate with you, whatever it may be, phone, email, pop into the office, but that they're going to communicate. So Good one. You want to talk about that one, Susan?
Oh, sure. Number 4. Yes. Well, I could also add a caveat on to number 3.
Please.
Also, when you think about the timeliness, it can be relative, because I do have beneficiaries that if they call me and I don't respond within 30 minutes, they're calling me again, or they're texting me, and some that will call on the weekends and after hours, and all my clients come right to my cell phone. So if I'm not in a meeting or on the phone, then I'm answering the phone. That doesn't mean that I can always give them exactly what they want right at the time that they want it. There's some things that, for example, if beneficiaries want more money or whatever, and it's outside the confines of the trust, I will probably have to go and make a petition to the court. I have some trusts that say, anything over $5,000 has to be court approved. So those things are really kind of out of my control in terms of the timeliness of when the court could hear them, and that does cause delays that people aren't, the beneficiaries don't always quite understand. But you should have a way to contact a live person, at least during business hours, and then if not, if you leave a message that it's getting to be answered, within, I'd say 24, 48 hours should be acceptable. And then number 4, choosing a fiduciary who farms out work to subordinates. Now, there are very large fiduciary firms. Mine happens to be relatively small. I do have people that work in my business, but they're not fiduciaries. They're more support functions. But for me, the liability is much less if I'm the only one accessing bank accounts. I'm the only one dealing with beneficiaries. I'm the only one who can pay bills. That's just how I choose to run my business. And so the fiduciary that you hire, if you hire me, then you'll always be working with me. Some firms, you hire the fiduciary, but you're working with subordinates who may be just fine, but you should probably know that going into it.
Right. It's really, and I'll come on this, it's really finding the balance between that. So because there's a reason why many times these beneficiaries have had their money left in a trust. There's a reason why, because they can't manage it on their own. And so you'll end up as a professional fiduciary dealing with people who cannot manage finances on their own. And they're sitting there calling you at 8 o'clock on Saturday night saying, I'm trying to get gas in my car and my card's not working. Fix it now. It's tough. And so fiduciary knows that, okay, first time I get that, we're going to deal with that. But if it becomes a repetitive behavior and they just don't learn their lesson, it's tougher to deal with.
We have a mutual client like that, and I can remember even two years ago on New Year's Eve, they were needing a transfer, and I was at North Star at the ice skating rink making a transfer so that they could get some DirecTV back on.
Yes, you gotta have that satellite TV. I remember leaving money under my what's it called, the doorstep, the mat, doormat, so that he could eat that weekend. Just crazy, some of these stories that people who cannot manage their own stuff. All right, next, last one here. Not choosing a fiduciary with the right skill set. So real estate management, nursing skills, money management. Obviously, and this goes a little bit back towards what Susan had mentioned earlier, when it's like you're dealing with, for example, a conservatorship, where it's like conservatorship of the person and the estate. The estate, you're essentially dealing with the assets and the money. The person, you're dealing with their medical care decisions. And I'm dealing right now with a case where we have a professional fiduciary that was appointed for both person and the estate. They're trying to manage the estate, there's allegations of elder abuse that are there, where one of the the children is stealing money from mom. So the fiduciary is trying to get the bank records to get to the bottom of that, and doing a really good job, quite frankly. Found that the son had stolen a bunch of money from mom. And so we've discovered that. And now we're going to go and try and take care of that. But then the fiduciary, the professional fiduciary, is not really great at managing the nursing care that needs to come into the home. And these caregivers, they're pretty bad. They've messed up the prescriptions. And also it's just, quite frankly, because of the turnover, they're always different people as opposed to just having the same people that come in. It's really kind of freaking out this conservatee. So that's something to consider. Like, is this person going to be good at managing medical care, managing the nursing home care, things like that? Or are they just literally a person who deals with assets, selling real property, for example, getting in, fixing something up, selling it, making a bunch of money for the beneficiaries? That's their jam. Great, wonderful. But maybe they're terrible at managing live-in house or caregivers, things like that. So something to consider, knowing what skill sets they have, what experience they have, are they good at it or not? Good. Stacy's back. That must mean she's like, we got to wrap this thing up, right?
I'm back. Thank you, Susan and Dan. Actually, I'm back to start our Q&A session.
Okay.
So if any of you, our participants have any questions for Susan or for Dan, feel free to type them into the Q&A box. Oops, I forgot to press this. Type your questions into the Q&A box now. Now we have a visual reinforcement. And I'm gonna pull it up here and I've got it open. I'll just give you a minute to think about it. And we'll see if we have any questions. If we don't, we'll wrap up here in a minute, but we did want to give you an opportunity while you have two experts.
Yeah,
Dan?
while they're typing their questions in there, I would say this. The thought that I've had is that, honestly, if all of our estate planning clients, if they use good professional fiduciaries, on the litigation side, would, quite frankly, I'd be out of work, if I'm being dead honest, because so much of our litigation, really, essentially all of it, it's beneficiaries and trustees who cannot see eye to eye. It's a bad trustee many times who's not answering to a beneficiary, and now that beneficiary, because the trustee thinks they're, basically God's gift to humanity, can do no wrong, that beneficiary has to drag that trustee into court and get them to answer. And so many times it's a family member who doesn't know what they're doing, has not accounted, or has messed up, quite frankly, took money and then spent it on themselves. And now the beneficiary is like, hey, that's not right. We end up having to obviously drag them into court and deal with that. But good professional fiduciaries, like Susan, they would save so much family conflict on that. It's just, yes, there's a cost to it, but I would say this: many times the family members are taking as much or more in fees than the professional fiduciaries. That's something that sometimes, unless the family member is doing it for free and they do a really great bang up job, it's hard to beat that, but if it's like, oh, I'm going to save costs, if that family member is taking a reasonable fee, many times it's even more than a professional would do. So
we do have a question, two questions now. So first question number one: if I name a professional fiduciary in my trust, can my beneficiaries change to a different professional fiduciary?
That's great. I would say I'm probably more suited to answer that one, I would think, Susan. X out of that. So it depends on how you draft that trust, because I've seen trusts where it says if all of the adult beneficiaries agree to change the fiduciary, then they can. But that is, I would say, more rare. Most trusts are drafted that once you as the settler who created it pass away, it's irrevocable. You can't change it. So that now this is who I wanted to be the fiduciary. that's who it's going to be. And so the fiduciary, assuming they accept, because it may be if you have all these beneficiaries who are going to lose their mind and say, no, we don't want that professional fiduciary. The professional fiduciary may just say, I don't even want to touch this case. And they may decline the appointment as the fiduciary. And then it would go to whoever you had listed next. But assuming they act, they accept their role as trustee, and then they go in there and they start doing everything, they do it properly. Can the beneficiaries go and petition the court to have that professional fiduciary removed? Sure, nobody's going to close the courthouse doors to that. But if the professional fiduciary has been doing everything correctly, those beneficiaries, they're going to lose, because the fiduciary is going to say, hey, I've done my job, I've followed the trust instrument, what it says to do, I've accounted properly, I've done everything right, followed the Prudent Investor Act, everything. And the court's going to look at these beneficiaries and say, why are you here? What are you trying to do? Why are you trying to remove this person who's been doing a really good job? So unless the trust instrument says, hey, yeah, all the adult beneficiaries get together, they vote on it and vote out the fiduciary, then no, they can't just say, nope, you're out, because that would essentially be saying changing somebody's trust or will after they're dead. You can't do that stuff. So hopefully that answers that.
Okay.
Any other thoughts, Susan, that you had on that?
No, I would agree that usually they can, if the fiduciary is not performing, then usually the beneficiaries can get together and then remove that fiduciary.
Right.
But in most cases, they just work with the existing fiduciary that's in place.
Yeah. If the trustee is doing a bad job, then of course beneficiaries go either lawyer up or do it yourself and go remove that fiduciary if they're not doing their job. Sure.
Okay, we've got two more questions. So let's move on to question number 2. This participant says, my wife will need a lot of help if I go before her in relation to the computer. All accounts are accessed on the computer, and she would rather go old-fashioned and use checks and statements on paper. Can I get some help for her in those first weeks as she transitions to widowhood?
That's a great question for Susan.
Sure. I've worked with clients in the past that hire me to help their wives in the event that they are going to go first or become incapacitated. And usually that's done on a financial power of attorney. It can be a certain time period or revocable by the wife once she's ready to assume all that, or it can be ongoing if she still needs help. But that would be handled usually through a financial power of attorney.
Okay, and this next question kind of ties in with that same idea, which is if we select a fiduciary that does that service need to start immediately, or how does the time to have the fiduciary services start? How is that determined?
Oh, so usually I don't start working until I'm named as a trustee. So for example, if I'm put in as a successor trustee, but I'm not acting as the trustee until the person becomes incapacitated or dies, then my services don't really start until then, and that's when my fees start. But up until that time, my clients can contact me. I meet with clients just to go over their current situation if they want to update me like once a year or so. I have a client that she has no family members, so when she travels, she notifies me that she's traveling, and then she notifies me when she comes back. And it happened once that she was in a destination and needed some assistance and could contact me. It was on a weekend. I was at a swim meet, but was able to help her, while she was at the hospital. But for me, there wasn't any charge for that. I'm just helping her until there's a need for me to act as the official trustee.
Okay, thank you so much. Thank you everyone for your questions. I just wanted to show you this last slide. If you're interested in continuing the conversation, you are welcome to contact our office for a no-cost initial consultation with an attorney. If you're new to us, there's multiple ways to get in touch with us listed here. If you have any questions for Susan, feel free to get in touch with her. You can email her or call her. Again, I will be sending out a PDF of these slides, so you will have all of this information by tomorrow. But we just wanted to thank you so much for joining us today. It's been a pleasure. Everyone stay safe, stay healthy, and let us know if we can help in the future.
Thanks, Susan. Thanks, Stacey.
Thank you. Thank you.
Bye.
Bye.